Good afternoon, everyone. Thank you for joining us. My name is Jessie Thaler-Moran. I'm an attorney in the Raleigh office of Brooks Pierce. I'll let my colleague Beth introduce herself in just a second, but thank you for joining us for our presentation, which we've titled Workplace Policies Under the Biden Administration, What's Old is New Again. We are going to spend the next hour talking about developments in the NLRA, NLRB sphere that affects employers, not just with unions in their workplace, but employers across the board. So again, my name is Jessie Thaler-Moran. I'm in our Raleigh office, and I will let Beth introduce herself.
Hi, I'm Beth Langley. I work primarily in the Greensboro office, and I'm so glad that you all have joined us today.
So here's our disclaimer. If you've joined us for prior webinars, please just remember that this is not legal advice. This is information. Today's presentation in particular is going to involve a certain amount of speculation on our parts and some very fact-specific analyses. And so please do not walk away from this presentation thinking that we are telling you that we know the way, capital T, capital W. This is kind of a new territory. So as I mentioned, we're going to be spending a lot of time today on the National Labor Relations Act and the National Labor Relations Board, which are derived both from the NLRA, which was enacted in 1935 to protect employee rights and encourage collective bargaining. So at the time, that meant things like unions. It has since evolved to mean employees coming together to address and improve their working conditions, hours, cleanliness, rates of pay, that kind of thing. The NLRB is the independent quasi-judicial body that enforces the NLRA. Each administration has the opportunity to appoint certain members of the NLRB, and so we see enforcement of the NLRA change a good bit between administrations. And as I forecast a minute ago, there are implications here for both union and non-union workplaces, which I believe most of the employers on today's call do not have unions in their workplace. Even if your workplace remains that way, there are implications of which you need to be aware. So the pertinent parts of the NLRA that we'll talk about today are Section 7 and Section 8. Section 7 protects employees' rights to organize and to engage in what the Act refers to as concerted activities. So coming together, again, to address those workplace concerns. Section 8A prohibits employers from interfering with employees' exercise of those rights. And as we'll be talking about later in this presentation, the definition of what it means to interfere with those rights evolves a good bit over time and by administration and even sometimes by decision. So just to take you through a little bit of background, I often hate when presenters start with, this was the law and it's not the law anymore, because it can be very distracting, but I think it is informative here for how we got to where we are sitting here today. It's been a little bit of a roller coaster in terms of the NLRB's enforcement of the NLRA, and particularly Section 7 and Section 8. So back in 2004, several administrations passed at this point. We had this Lutheran Heritage case come out that said a rule like a workplace policy that does not explicitly restrict that protected activity could still be unlawful if one of these three things applies. If an employee could reasonably construe the rule to prohibit Section 7 activity, and we'll hear more about reasonably construe in a minute. If the rule or policy was promulgated in response to union activity, so think about, now as we're hearing that we may see a shift towards unionizing in the workplace, rules that are enacted in response to that could potentially violate Section 7, or if the rule has been applied by the employer to restrict Section 7 rights. So if the rule on its face is not problematic, but the employer has applied it in a problematic way, it could still violate the NLRA. So that's back in 2004. Then we enter the years of the Obama administration, and that term reasonably construe is interpreted really broadly. And just to give you an example, there was a decision in 2014 involving this company, Purple Communications, and the board says the use of email for statutorily protected communication on non-working time must be presumptively permitted by employers who provide email. So that means if you've provided your employees with email or with a phone, or any other workplace technology, it's presumed that they can use that to engage in concerted activity to essentially contest working conditions that you've put in place as their employer. We're going to talk a lot about this 2015 memo from the NLRB's general counsel, but that was kind of the guidepost for handbook and workplace policies during that era. Talks a lot about that reasonably construed language. Then we get to the Trump administration and we see a big shift in the assessment of workplace policies. So Lutheran Heritage, that 2004 decision, is replaced in 2015 by the Boeing Company, 2017 by the Boeing Company. And it replaces that 3-factor test with a balancing test. So you have the extent of the potential impact on NLRA rights and the legitimate justification for the rule. So you end up balancing those two to determine if the policy is permitted. And then just to give you an example, last slide I talked about purple communications. In 2020, the board rescinds that decision in favor of a policy that says employers can regulate their provided equipment, including email, so long as the restrictions are substantively neutral. So that permitted employers to put in place policies that restricted what employees could use, say, email for. A lot of you probably worked with us during that time to revamp your social media and electronic communication policies in reaction to that development in the law. And then we get to 2021 and we have a new administration. And with that, we have a new NLRB and a new NLRB general counsel. And she released a memo in August that announced that we are going to see some changes. And so with that, I'm going to turn it over to Beth to talk about some of the changes we're expecting.
Great, thank you, Jessie. Jessie said we're not clairvoyant, but sometimes when things are just right in front of you, you just can't miss it. So in February, we did a webinar about things to expect in the Biden administration. And one of the topics that we talked about were changes in the NLRB. And if you recall, if you were at that webinar, the acting general counsel at the time, Mr. Orr, had just come into office in his acting role with the NLRB and rescinded, just a whole bunch of guidance that had been issued in the Trump administration. So it was hard to miss that we were going to have some changes. And at top of the list were a lot of handbook changes. So what we have now with a general counsel who was approved by the Senate in July, and then 1 month later issues this memoranda that goes out to all of the regional officers and directors of the NLRB saying, this is how I want you to handle charges and cases that are in front of you. And it starts out like, and it's public record, so we can all read this. And it starts out with saying, here are our most important issues, that there are areas, this is quoting the general counsel, Jennifer Abraza, I believe, that compel centralized considerations in this regard over the past several years, meaning the prior administration. The board has made numerous adjustments to the law, including a wide array of doctrinal shifts. And these shifts include overruling the prior legal precedents. And basically she's saying, we're going to go back to the way it was. And then as you continue reading the memo, there's additional very pro employee, and I don't have a personal opinion here. We're just going to tell you what the memorandum says. So moving on to she breaks it into 3 parts, and she says there are particularly precedents that they're looking to overrule. She sets out initiatives of the NLRB that as general counsel that she wants to focus on, and then what's referred to as case handling matters like process. So let me talk to y'all just a little bit about the NLRB process. If you've not, for those of you have not had the experience of defending an NLRB charge, it's not like the EEOC. It's it is a federal agency. The process is just different. It's employees can, any non-managerial employee, so non-supervisory employee, can file a charge with the NLRB for matters within their jurisdiction. So it's usually what's Jesse referred to as the concerted protected activity. That's really any workplace concern. For us right now, what we're seeing are safety concerns. There are, all of the COVID issues. We're seeing a lot of even reductions in force. If there's a reduction in force and employees say that's made it unsafe, or I was chosen because I complained about wages or workplace issues, just think about when you think about the terms and conditions of employment, an employee complaining about it, that gets you into protected concerted activity. Concerted just means they talk to somebody else, and it doesn't have to be face-to-face. It can also be that they raise issues on behalf of somebody else. So it's very broad.
And that just to jump in really quickly, that involves posting on social media. So to the extent you hear about an employee who's posted on Facebook or any other medium that they're unhappy about something at work, that could very well be protected activity.
Exactly. Thanks for that, Jesse. So any medium, and it doesn't have to be statements made in the workplace. So social media, it can be activities that take place outside of the workplace that an employer makes a decision about. So the charges start with an investigator. Things are all online, but the investigators have the same mission of that the general counsel is setting out. And then employers have to file a response, but things to keep in mind where it's not like, say an EEOC charge, it's not like, oh, well, we can send in a position statement or we might get a mediation request. There's not that sort of process. There's an investigation, the actual complaint could be filed. The NLRB could go to federal district court if it's a matter where they think that an employee's rights have been abridged and they should go get an injunction against the employer. So again, it's just really different. If the matter is not so-called resolved, then there is actually a hearing before an administrative law judge. Any appeals go to the National Labor Relations Board, first a panel, then the full board, and then any appeals from there go to a federal circuit court. So it's expensive, I guess is what I'm telling you. And it's just very, very different from an EEOC process that most of us are used to. So in this memo, knowing that that's our backdrop, and we've been here before, but there's a preview of what the NLRB is going to be focusing on. Employer handbook rules. So if many of you remember kind of the Obama administration, to some degree in prior, maybe in some degree in the Clinton administration, there's a big focus on employer handbook rules with non-union employers. Things such as policies like that govern work times, what you can, just how you word the handbook in itself, where there may have been no concerted protected activity, but NLRA comes in and says, as part of response to a Section 7 charge, they want a copy of your handbook. And then they find that you violated the NLRA because of your handbook. A lot of that was going on. in the Obama administration. So this is a good time, if you've not reviewed your handbook in a long time, that it's have someone do that with an eye toward knowing this is what the current board is, this is their mission and their vision. Confidentiality provisions and separation agreements. The focus here is on terms that prevent employees from discussing amounts, from saying anything disparaging about the employers, any sorts of restrictions on what the parties can do going forward that may have what the phrase is always the chilling effect of discussing unlawful conduct, or what the board perceives as that. This whole concept of just exactly what is protected concerted activity, I think even just as technology changes, that's one of the aspects that comes into it. As the definition gets broader and broader. One of the big issues on this list, remedial issues, and this is huge. There's a large focus on what is the recovery for someone who, say, was fired for what the board determines is concerted protected activity or some other violation of NLRA. And in addition to back pay, the general counsel's memo outlines basically all consequential damages and gives as examples. If the person lost their job, then maybe they lost their housing. So all of the damages related to lost housing. If they couldn't pay their credit cards, then all the damages related to lost credit and those sorts of things. So it's really every sort of incidental consequential damage you can think of that they are now including as damages for recovery, in addition to just back pay, interest, any attorney's fees, those sorts of things. Union access, union dues for non-union employers, that's not as big an issue, but do be aware that there is increased activity for union organizations, union organizing. I think another thing to really be aware of is employee status and this whole issue of who is an employee. You may have seen on the news in the last month or so, this determination by the NLRB that college athletes are employees. And, it's that sort of paradigm shift that we're going to start seeing. So, and by changing the status to employees, then those individuals now have the right to organize. And so that's, it's a broader pie, if you will. There's also a big focus over, again, I'm not going to spend too much time on this, but religious institutions, and if there's the board's jurisdiction over those types of employers. And again, that's kind of a back and forth between some Supreme Court precedent and the board. And those are the really big ones. Jesse, what are some of your thoughts on?
Well, I realized really as you were talking, I had like 2 jobs when I started the webinar and I failed to do one of them. So let me say now 2 things. If you have questions as we're presenting, please use the chat box to submit those questions. And there will be a SHRM code that comes up at the end of this presentation. So if you've already signed off before now because you didn't know how to ask your question, I'm sorry. But for those who have stuck around with us, that would be how you ask us questions. One thought I had, Beth, with the renewed emphasis on union access and dues and the duty to recognize is that there are, in conjunction with this increased unionizing activity that we're hearing about and anticipating, a lot of union consultants who are out there in the world. And, when our clients confer with us as attorneys, as our clients, there is a protection over that privilege that umbrella doesn't ordinarily extend to working with a consultant. And so it's just something to be aware of, that someone who may have very good points when it comes to working with your workforce around unions, there's not a privilege protection over that.
It's a good point, Jesse. There are ways we can work with consultants, but yeah, that's something to be aware of, and be aware of documents that get created. Mm-hmm. So when we look at the handbook rules, some I would say hot button issues to think about. Really take a look at your confidentiality rules. If they're really broad, if you can't disclose anything, I mean, the main issue is you're going to have to be very specific about what is proprietary, what is confidential. It can't just be a blanket rule. Non-disparagement is the same way. It's going to be, I think as a term we kind of got used to for a long time was that, you can't make statements that put the company in a bad light or something like that. Those aren't going to hold up with this board. They're going to say that has a chilling effect and would be reasonably construed to violate Section 7. Social media policies, anything that's really broad that says you can't make disparaging remarks, or you can't post on social media, you can't post anything about the company on social media, those are probably going to be struck down. Same with media communications. One thing that we have, which is good, is we kind of have a roadmap from what things that they said were okay in the Obama administration, and many of the same individuals are back on the board and in managerial positions here. So we know what worked the first time. Here's a question about, do confidentiality and non-disparagement agreements apply to executive contracts? Management officials are not covered by the National Labor Relations Act. So it's only non-management employees. So when we're talking about these, this list of issues, we're talking primarily about handbook rules and other policies that get disseminated throughout all of your workforce. There's no jurisdiction over your managerial employees, which includes supervisors, but it has to be supervisors who are actually supervising people, not working supervisors. That gets to be a factual issue. You get a lot of broad language in handbooks, like, you must treat everyone with courtesy and respect. And, that sort of broad language is likely to get struck down. Same with any, language like, you must work your set schedule. That's been interpreted to mean that employees can't strike. And some of this is counterintuitive. Of course, you've got to work your work schedule, but if you're looking at it from opposite land of, oh, well, you've got to write this from the viewpoint of someone who, is not looking at it like you're running a business. So that's almost the viewpoint you've got to look at it from, of how would a union organizer look at your handbook rules, and does it would it make someone who feels like they need to leave the workplace because it's unsafe, would it make them think, oh, I'm violating my handbook? So that's the angle that they're looking at this from.
So Beth, if you're an employer and you're looking at the laundry list of items on this slide and the prior one, I mean, what's the main takeaway with regard to handbook rules under this new board?
I think that for me, the main takeaway is that shorter is better. Less words, have less policies, and just get to the heart of what it is you need to convey in your handbook. Because the longer it is, the higher likelihood that they'll find something wrong with it.
And I moved you to the next slide without meaning to.
Okay.
You're right.
We talked about confidentiality and non-disparagement clauses. I think that's just going to be, if you're entering one of those with the NLRB, you're just going to duke out what your terms are. In any other setting, I think we already carve out NLR, that employees can go to the NLRB, and I think non-disparagement clauses we use just with discretion anyway. Who you're going to put them in with, when does it make sense, when does it not? So I think that let's just be very that it shouldn't just be a blanket provision you put in with everybody. And let's just think about that. Is if it's a non-managerial employee, odds are they're probably going to talk about it anyway, and they may say something bad about you, but is that worth risking getting crossways with the NLRB and having your settlement agreement determined void? I mean, you're just going to have to do a cost benefit analysis on that. Other sorts of rules, they don't like arbitration agreements. They're constantly litigating that sort of issue, and they're litigating that up against the federal law that does like arbitration. So I think that's a fight that just let that get worked out over, on somebody else's dollar, and see where the dust settles on that is my call. But these other rules, in any sort of confidentiality space, it's going to be fact specific, and that's the one thing that we did learn in the last go round, is that for the most part, there's going to be a difference if you're in a really, I think, high-tech industry, or if you're in an environment where there's a lot of trade secrets and confidential information versus when there's not. And I think that's going to be taken into consideration, and I think draft your agreements and any provision in a handbook or separation agreement accordingly.
Seems like one of the takeaways with respect to handbooks and to a lot of these policies and agreements is that if you have been working off of the same document for a while, or even at this point for more than a year, it would be a good idea to have counsel review them.
Absolutely. Absolutely. Because everything has changed. Absolutely. So, we talked a little bit about what constitutes protected concerted activity. Jesse spoke a little bit about employer provided technology. I want to just kind of expand on that just a little bit. There's now a presumption that if you provide a laptop, a phone, a computer, that employees are going to use that for personal reasons, and that just a blanket prohibition to say you can never use those for personal reasons is probably going to get struck down. The NLRB is going to say, because they may need the computer or phone or whatever to email NLRB to file a charge or to call them and complain or something like that. But a blanket prohibition, if you've got that in your policy, you would be much better just rewording it to something like, to limit personal use or something, but not have a blanket. Another policy that we often see is, a policy that just has a blanket solicitation, like, no solicitations or any type are allowed on company premises, that's probably not going to hold up either, because they know that what most companies are trying to do is to prevent union organizing. So, think about whether it's worth just drawing that argument or having, going about that a different way of, employees are not allowed to, sell items or to lobby for any blah, blah, blah. Now, the problem of doing that is, a lot of companies allow someone to come in and bring their kids, Girl Scout cookie form or, whatever. And so, taking the approach of, I'm not allowing solicitation, but then you have a list of favorites that you do allow, really does set you up. So that's a topic that I often just say, don't address it. We don't allow you to sell items and we don't allow gambling, but, I would just be careful about that, because that's one thing they're looking for. The same as like, don't talk about wages, that's another one. This is an easy target that they'll get you on. The misclassification, and that's whether you're identifying someone as an independent contractor, whether you're saying someone's just not an employee at all, or this whole issue of who's a supervisor versus who's a non-supervisory employee. Those are all on the radar of the NLRB right now.
Okay.
So Jesse, what now?
So, we are not mind readers. I personally have not finessed my crystal ball gazing. Maybe Beth has. So what we're going to do next is kind of take a dive into our best educated guess of what's coming and what employers can do to prepare themselves to not be targeted for an NLRB investigation. So again, going back to that 2021 memo, she's forecasted an intent to roll back the prior administration NLRB authority in several areas involving handbook policies. So as I mentioned a few minutes ago, revisit those policies and those templates. If we or someone else has helped you draft a separation agreement at some point, our preference is always that you check in with us before you reuse that. But to the extent you've got a template that you've been relying on for a while, or a policy that's been around for more than a year, it's a really good idea to revisit that, make sure that it's drafted really tightly, run it by your legal counsel. And then our best educated guess of guidance, while we wait for more official guidance, is a memo that was released in 2015 by the NLRB General Counsel at that time. So I'm going to walk through some examples that memo analyzes as kind of a paradigm for how to look at your workplace policies. And so here's a quote from that 2015 memo. He says, although I believe most employers do not draft their policies with the object of violating the NLRA, the law does not allow even well-intentioned rules that would inhibit employees from engaging in activities protected by the Act. And so the tone here is really, it doesn't matter what you intended. It matters if someone who's really cautious or really pro-union would read that policy to inhibit protected Section 7 activity. So the memo goes on to say that the vast majority of handbook violations they see fall under that first prong from Lutheran Heritage. Remember, there were 3 different prongs. The first being that an employee could reasonably construe that policy to prohibit Section 7 activity. And remember that during the Obama administration, this was really broadly interpreted. I will also note here that the analysis is context specific. And so a lot of these sample policies we'll walk through might seem very similar, but in the context of the particular employer or the particular policy, the NLRB found these to be permissible. And so what this memo does is walk through, for different categories of handbook policies, This is an example of something that's not permissible, and this is an example of something that is. So we'll use confidentiality first. We've got double layers of disclaimers here, right? This is an example. Please do not take this and just drop it into your handbook. Generally, a confidentiality provision will be lawful so long as it's targeted towards business information and not information involving employees or the terms or conditions of their employment. So what is unlawful? A policy that prohibited discussing customer or employee information, which included phone numbers and addresses, or broadly defining confidential information to include all information which loss, undue use, or unauthorized disclosure could adversely affect the employer or their image or reputation. That's really broad, and the NLRB said that wouldn't fly. By contrast, a prohibition on the unauthorized disclosure of business secrets or other confidential information in a certain context was okay. So to the extent you have a confidentiality provision, the NLRB is suggesting here, the more narrowly it's tailored to business secrets, you know, whatever the secret sauce is of your business, the more likely it is to be permissible.
So Jesse, I'll give you an example. I would say somewhere along maybe 2014, 15, something like that. I had a situation with a client where employee filed a Section 7 violation charge, and there was nothing. The underlying charge itself, there was not a violation, but again, they found a violation for the handbook, and it dealt with the confidentiality provision where confidential information included financial information. And because the employer had not broken out financial information into different categories, then the board determined that that was overly broad.
Because it could include things like wages and rates of pay, I guess. Yeah. And so that's a great example. We ordinarily think of financial information as something that's obviously worthy of protection, and the board feels like that needs to be more narrowly defined. So employee conduct, workplace conduct rules. Employees have the right to criticize workplace policies or the treatment of employees. And so what we saw a lot in the prior administration was policies trending towards, mutual respect and being polite and those kinds of things. Those types of policies are probably unlawful in the eyes of the current board. The 2015 memo says it's unlawful to just have a policy saying be respectful of others and the company, to prohibit disrespectful conduct or insubordination, including refusing to follow orders, to refrain from action that would harm the company's business or reputation. And then this last one is interesting, to prohibit insulting, embarrassing, hurtful, or abusive comments about other company employees online, and to avoid the use of offensive, derogatory, or prejudicial comments. And we read that, through the eyes of someone who also is aware of an employer's Title VII obligations to keep employees free from harassment. And there is this really fine line to walk between writing something that protects employees from harassing conduct and something that isn't construed as so broad as to prohibit anything negative about the company or supervisors. By comparison, it's lawful, according to the board in a specific context, to prohibit rudeness or unprofessional behavior toward a customer. So note that's outward facing as opposed to your supervisor. And so in general, protections of the product, of the customers, anti-harassment, Title VII policies, generally going to be lawful so long as they are very carefully drafted. Third-party communications, so talking to people outside of the company. Employees have the right to communicate with news media, government agencies, and other third parties about working conditions. If you have a media policy in place in your handbook or otherwise, this is the time to pay attention. Now, I'm sure you're all listening with rapt attention and are fascinated, but now in particular. So it was found unlawful to prohibit employees from speaking with a member of the media about, quote, company matters, unless you had prior permission. To require all media inquiries to go to a specific representative or to a hotline is unlawful. And then this quote here, if you were contacted by a government agency, you needed to notify the legal department immediately. That was found to be overbroad.
And these are situations where you think about if you're a publicly traded company, you have to have a spokesperson to make public facing comments. And again, if you want to make sure that the legal department is contacted if a government agency shows up. These are common sense sort of things, but if you're looking at it from the angle of the board, they don't want to have a chilling effect on whistleblowers is basically what they're looking at.
Mm-hmm. So another place where you don't need to refrain from having a policy, but just be careful, it's drafted very specifically. So, the example of the lawful policy is really not that different, which is why we're saying it's in part context specific. The company strives to anticipate and manage crisis situations, to reduce disruption and maintain our reputation. To best serve these objectives, the company, not individuals, but the company will respond to news media in a timely and professional manner through the designated spokesperson. So I think part of what got this policy past review was that it talks about what the company will do as opposed to communicating with media in general. Intellectual property. In general, you can't prohibit fair protected use of intellectual property. So even if it's your company secret sauce, there might be situations where that could become relevant. Generally, it's going to come up with like names and logos, those kinds of things. So this example, you can't use the company's name, address, or other information in your online profile. You can't use their logos, trademarks, or any other copyrighted material. And you could see potentially a situation where you want to use those things to convene with others or to generally protest wages or scheduling or something like that. By contrast, here's an example of something that's lawful. A reminder to respect copyright and intellectual properties laws. It's critical you show proper respect for those laws, including the company's own copyrights, trademarks, and brands. And so this one has a lot less teeth to it, but is at least provided by the board as an example of a way to kind of toe that line. Conflict of interest. This one it kind of makes sense if you think about where we're sitting in this balance between employers and Section 7. Employees can engage in concerted activity to improve the terms and conditions of their working environment, even if doing so places them at odds with the employer's interests. So it makes sense, right, that if employees are convening to demand higher rates of pay, that would not necessarily be in the employer's best interest. But that doesn't mean you can prohibit them from doing so within your conflict of interest policy or otherwise. So again, a very broadly worded statement was found unlawful. You can't prohibit any action not in the employer's best interest. And then in this section of the memo, there are actually several examples of a lawful conflict of interest policy. And what it really comes down to is defining that policy thoroughly and with examples, because you want an employee reading that policy to understand very clearly that their protected concerted activity is not prohibited. So like engaging with competitors in the marketplace, for example, those kinds of things are generally going to be lawful as long as they're written very clearly. And I'm sorry, Beth, I think I jumped over on one of your slides. I'm going to hand it back to you now.
Thanks, Jesse. I think if we go one slide back, if we can. There we go. Okay. So there are going to be times when you're going to have to figure out where's the balance here between complying with Title VII. We have a lot of local ordinances now that have very similar, but maybe even broader protections than Title VII. And these obligations that are very real under the NLRA. Social media postings, maybe, that have slurs against managers that use words that we would think automatically, that violates Title VII or some other sort of anti-discrimination or anti-harassment ordinance or statute, the NLRB may not agree with you. And that has been an issue, and I believe will continue to be a heightened issue. One of the points raised by the General Counsel's memorandum is that the board would continue to review areas where there's conflict between the NLRA as interpreted by the board and federal, state, and local laws. So there is an awareness that there is a conflict, but this memo did not provide the answer on how to resolve those conflicts. So my, I guess, thought on this is there's not an immediate, yes, I can fire somebody because these words were so horrible that were posted on social media or used elsewhere, if that conduct can be construed as protected concerted activity. It's really going to be a case-by-case analysis as to what's the best approach in that situation. And again, even though you've got federal law here and federal law there, it needs to be a balancing test and consult with counsel as to which way you need to ultimately decide as far as disciplinary action goes. Again, we've talked some about this whole concept of how a policy will be interpreted, but I think from general guidelines and takeaways, it's, as Jesse's got here, it's not just what you said, it's and the how you said it, but how's someone going to interpret it? You may have a very harmless policy, but if it can be interpreted as a broad prohibition that's going to, in someone's mind, as a union organizer or an employee who wants to protest some sort of workplace condition, that is going to prevent them from doing that. Even something as simple as you'll be terminated for insubordination. Well, what does that mean? Is insubordination, can that be interpreted to mean that you're going to fire me because I refuse to engage in unlawful conduct? That's a vague policy, but you see that a lot. Same with situations with working time restrictions or restrictions that say, if you're off duty, then you must leave the premises. Those sorts of blanket policies, because like that last one, someone had, they have the right to strike, they have the right to picket, so you can't prevent union organizing. Some other kind of definite do's and don'ts. It's really not a good idea to have policies, that says you can't make any sort of statement without prior approval. Some of the other, topics we've touched on, blanket prohibitions on using email or phones or any other company equipment. The real gotcha one that folks fall into is the discussion of wages or any sort of work conditions. The work condition issue, I think, gets camouflaged sometimes by other policies, because it may be something as simple as, and I've seen this one before, a company who the board held that their open door policy violated Section 7 because it said that they had to, basically it had a chain of authority where an employee had to voice concerns. So the interpretation was that by having a certain, hierarchy, that what you're saying is this is the only way you can voice concerns. So, again, you have to kind of think of things in a way that we're not used to looking at that perspective. Threatening, I think in COVID land, as we are still almost 2 years now, no one makes the threat to someone. I mean, I don't think anyone on this call says, I'm going to fire you if you don't do so-and-so, but it comes about in other ways. As we're approaching this imminent vaccination mandate, think about how things are going to be interpreted by employees. What's a threat of termination? Look at it from someone who's vaccinated, someone who's not vaccinated. We're just going to have more unrest. So this is going to be a time when employees are going to be, will continue to be, I guess I'll say, in kind of a heightened state of just antsiness. And so things get interpreted as a threat without saying the words. So think about those sorts of things in your interactions with employees, whether it's in a memo, an email, a face-to-face conversation. Just be very aware. Same thing about any sort of discipline. If someone is raising a concern, my thought is that very well may be concerted protected activity if there's anybody else around, because that's a condition of employment for most parts. If is it there? The airflow, is it? Most things now are some part of a condition of employment. So just consider Section 7 when you're going through the disciplinary process.
And Beth, this is reminding me of just the general maxim of how important it is to manage performance along the way. I think a lot of people don't like having uncomfortable conversations about employee performance. And then we see things happen even during the prior administration where, you have a low performer who now has a medical need or goes on leave or something like that. And suddenly it appears as if an action taken by the employer is potentially in retaliation. And this will be one more way that, if a hard conversation is put off for too long, and then there's an intervening event where there is protected activity, it becomes harder for the employer to follow a planned disciplinary process if there's not prior record.
Excellent point, Jess. So final reminders. Every matter is case specific. I mean, the point Jesse just raised is excellent, that follow your best practices all along the way. But it is a really good time to dust off policies, to take a good look at them in the context of what has been previewed are going to be the priorities of this board. We aren't mind readers, but we can take the information that the general counsel has already provided to us and use that in a way to prepare for what we believe will be their priorities and will be the way that charges are going to be handled. Please consult legal counsel before you get a charge, definitely if you get a charge, and we're glad to answer any questions that you may have along the way.
Including right now.
Nice segue. We will post both this webinar and the slide deck. And it will probably be at least 24 hours before it goes up. Today's Wednesday. It'll be up by Friday. And if anyone has any questions, they want to reach out to us individually, we're glad to answer any questions that you might have.
Thank you for attending today's presentation. We'll now end the webinar.